Okay, so this lecture is looking at defamation, which is quite a hefty, case-heavy topic, and also statute-heavy as well. So defamation comes under various forms, such as libel and slander. Libel is the publication in permanent form. Damage here is pretty much presumed, whereas in slander it's publication in transient form, so impermanent, and these generally require proof of special damage. There are exceptional cases where you can claim on slander without proof. So this is the imputation of criminal conduct or the imputation of unfitness in business. They used to have imputation of certain contagious diseases and unchastity. However, these have both been abolished and are no longer applying current law. So there are 3 different elements to a defamation claim. The first one is that the material is defamatory. Second is that it refers to them specifically, the claimant, and thirdly that it is published. So what is defamatory? So in semi-stretched, it's basically defined as anything which would lower the claimant's reputation in the eyes of right-thinking members of society. In Berghoff, journalists made remarks about the actor's looks, and defamation was defined as something which would expose the claimant to ridicule and contempt. In Charleston, there was a photoshopped naked picture of the actors, and I think they used their characters' names in the title, and there was bondage equipment, and they tried to claim against this, saying that it's defamatory. However, it was held that it wasn't, but this was only because the article actually stated that this image was fake. If you look at the Defamation Act of 2013, in Section 1, it says that it's not defamatory unless it has caused or is likely to cause serious harm to the claimant's reputation. This is quite a high threshold, and this is supported by Independent Print Limited, where the defendant made a false accusation of kidnapping against the claimant, and this caused her unjust prosecution in the UAE. Then we can also look at Byrne. So this was where journalists reported on illegal gambling happening in the back of a club. I think it was a golf club or a country club, something like that. Everyone knew it was happening, but no one had actually ever reported on it. And they put up a sign, basically calling him out, saying that they know it's him, and it made him out to basically be a snitch. And the courts held that this is a different standard of opinion. To other members of society, they may think you're very honourable for reporting on something like this. There's a different standard of opinion here. Also in Lewis and Daily Telegraph, here there was use of an innuendo. So there were 2 pictures put next to each other. However, there was a very innocent statement next to it, and it basically brought up this idea of, is there a hidden meaning there? Can you claim for defamation when there's an innuendo? The second element was that the statement referred to the claimant. So in Byrne, which we discussed earlier, the thing actually read "burn in hell," and Byrne was spelt with B-Y-R-N-N, which is actually misspelt his name. Instead of the second N, it would be an E. But it was pretty clear that it is talking about him, just by changing the spelling of the name. I think it's the same as like the innuendo, it's a pun here. The case of Jones, the newspaper had a fictional character, and they used the same name as the person. I think it was unintentional, but because the claimant was being mistaken for this character, they ended up suffering harm. So the statement actually, it's not relevant who it was meant to affect, but who it actually affected. This is supported by Newstead, where they were talking about bigamy, and they used the man's name. However, there were 2 men, very similar in age, very similar in area, and the article ended up actually affecting the wrong person. However, in O'Shea, there was a model for adult internet services, and the claimant said that she looks very much like her, she was being mistaken for her, etc. However, the court held that this was purely coincidental, and also that the company has freedom of expression. It's the Article 10 right they have freedom of expression, they're allowed to use any model that they'd like. And because it was coincidental, that it wasn't defamatory. And there are also cases of group defamation. So in a London Express, it was held that in order to use group defamation, you have to either prove that the group is so small that it applies to every single person in that group, or that it applies to you, the claimant, specifically. And then lastly, we'll look at the fact that the statement has to be published to a third party. So if you're arguing with someone and you accuse them of something one-on-one, it's not defamation. You haven't lowered their reputation in the eyes of a right-thinking member of society. It's pretty much just like a simple fight between two people, or a simple argument. In Huth, there was a letter sent, and the butler actually opened it and read it. I don't know if he opened it, but he ended up reading the thing. And it was held that this wasn't defamation, it wasn't publication to a third party, this element hadn't been met, because it was unforeseeable that the butler would have read it. This is very similar to Theka. However, this was decided differently because her husband opened the letter, and it was held that it would be foreseeable that her husband would possibly open a letter sent to her, addressed to her. And so it was defamatory. There was publication to a third party. Next, we can look at Bunt and Google. So these are cases where the internet is involved. So in Bunt, it basically says that, so it's when you repost an image or you like it, something like that, you interact with a post. This basically says that you have to have knowing involvement to be liable. In the case of Tammy's and Google, there was, I think, blogger.com. There was an Islamic blog, and there were really racist, Islamophobic and racist comments on these. Google was notified, however, it took them really long to remove these comments. And they're saying, at this point, are you becoming the publisher, since it's your platform and you're keeping it there? Section 8 of the Defamation Act 2013 brought in the single publication rule. So rather than there being a tweet and then every single person who interacts with that tweet being a new claim, there's just the original claim of whoever tweeted it in the first place. It's a single publication, the first publication, unless there's a separate publication, obviously. There are defences here. There's a lot of defences, and the burden for these is on the defendant, obviously. So there's truth, honest opinion, privilege, publication on a matter of public interest, the offer of amends, innocent dissemination, and also other defences. So in truth, this is an absolute defence under the Defamation Act of 2013, Section 2. And in Edwards and Bell, it was basically decided that the statement need only be substantially true. If there's something slightly incorrect, but the overall statement holds true, that is satisfied. And in the Rehabilitation of Offenders Act 1974, Section 8, it says that if the statement in question is in relation to a criminal offence, you only need to prove that there has been a conviction. We can then move on to honest opinion. So again, this is an absolute defence under Section 3 of the Defamation Act 2013. So in BCA and Sin, there was a journalist who wrote under the comment and debate section, basically saying that the BCA is promoting all these bogus treatments, they have no evidence to support it, blah blah blah. And it was held that it was clearly an opinion, it wasn't a fact, because they took the words to be quite straightforward. It was the literal meaning. It was the comment and debate section. There was nothing saying this is factual. The whole debate thing means it's up to your own opinion. It's what you believe. And we can also look at Section 3.3 of the Act, which basically says what information is this based off of. So this is supported by Spiller, which says that the comment must explicitly or impliedly indicate the facts on which it is based. So if you're making a defamatory statement which you believe is true, why do you believe that? We can then move on to privilege. So this comes in two forms, absolute or qualified. And again, there's common law, there's statute. So in Reynolds, Lord Nichols basically said qualified privilege is where there's common convenience for the welfare of society. And in Clift, this case there was someone who was put on the violent persons register for I think 18 months by the local authority, and they ended up sending this information to a vast number of people and services. It was sent excessively, and it was held that this clearly wasn't a matter for qualified privilege, and it only had to be sent to the relevant persons, not just anyone. In terms of statute, it comes under the Defamation Act of 1996, Section 15, but this was later amended in the 2013 Act and is now covered under Section 7. It is worth noting that this defence will be defeated by malice. So we then move on to publication. So this is in the Defamation Act, Section 4, and we look at the case of Economou. So there was a woman, she accused Economou of rape. I think the case was taken over by the Central Crown Prosecution Service, and a lot was going around saying that she was lying, etc., and she ended up actually killing herself. Her father then went to the press and saying that he wanted an investigation into this, a lot of things. He spoke to the press a lot. He didn't name the claimant, however, it was quite obvious who it was. And so they tried to claim that this was defamation. However, it was held that this was actually in the public's interest, and he had reasonable belief that it was in the public's interest, which is why he went on and talked to the press. Next, we're looking at the offer of amends. So this is basically where there was unintentional defamation. So in the case of Express Newspapers Limited, there's 4 different steps. So the defendant has to admit that they're wrong, they have to offer in writing to make a suitable correction or a sufficient apology, they have to offer to publish this correction and apology in a reasonable practical manner in the given circumstances. So if the defamation occurred in the newspaper article, there has to be a newspaper article put out to publish the correction and the apology. And then lastly, that they offer the claimant compensation as appropriate. Next, we're looking at innocent dissemination. This is in the Defamation Act 1996, Section 1, and this is where the person has a defence if they're able to show that they were not the author, the editor, or the publisher of the statement, that they took reasonable care in its publication, and that they did not know and had no reason to believe that they had caused or contributed to the publication of a defamatory statement. These are all the defences that we're going over, and I think there's no limit to which defences you raise. They're able to, as a defendant, you're able to raise as many as you need to.